I found out from a real estate listing. Not from my father. Not from his attorney. Not from the neighbor who still sends me Christmas cards. From Zillow. Charming colonial in Evanston, recently renovated, motivated seller. 3 exterior photos. New paint. New shutters. The same maple tree in the front yard that I climbed when I was 9. Status, pending. I was sitting in the oncology billing office at North Shore University Health System when I saw it. The woman across from me was explaining deductibles in a flat, rehearsed tone. Miss Whitaker, your father's secondary coverage only applies after the annual threshold is met. I nodded, barely listening. Then my phone buzzed. A Redfin alert. I never unsubscribed from alerts in that zip code. I told myself it was nostalgia. I opened the link without thinking, and there it was. 237 Linden Avenue. The house I grew up in. The house I was still paying property taxes on. The house I had just wired $42,000 to preserve from foreclosure 6 months earlier. Listed by an agent I'd never heard of. Seller, Martin Whitaker. My father. For a moment, I genuinely believed it had to be a mistake. Maybe a duplicate listing. Maybe a clerical error. Maybe someone scraped the address wrong. But the photos were new. The hydrangeas were trimmed. The porch light had been replaced. The dent in the garage door, the one I made when I backed out too fast at 16, was gone. Someone had repaired it. I scrolled down. Interior fully refreshed. Refreshed. I had been sleeping in a vinyl hospital recliner for 3 weeks while my father went through immunotherapy for metastatic lung cancer. I had taken unpaid leave from a consulting firm. I had drained $186,000 from my personal savings in 14 months. Medical copays. Experimental treatment gaps, private home nursing, back property taxes, roof repair after winter damage. Every invoice came to me. Because when my mother died 8 years earlier, my father said, "You're the responsible one, Claire." Claire Whitaker, 41 years old, single, no children, a healthcare operations consultant based in Chicago, the responsible one. My younger brother Aaron lives in Denver. We speak twice a year. He sent flowers when Dad was diagnosed. He did not send money. So I sent money. Because the house mattered, not for resale value, not for equity, for memory. My mother painted that kitchen cabinets herself in 1998. Pale yellow. She said it made winter feel shorter. My father built the backyard deck with a borrowed nail gun and 3 wrong measurements. We carved our heights into the basement support beam. The pencil lines are still there, or were. I stared at the listing until the billing coordinator asked if I was okay. "I need to step outside," I said. In the hallway, the fluorescent lights felt harsher. I called my father. He answered on the 4th ring. "Hey, kiddo." His voice was thin but upbeat, the performance voice he used with nurses. "Dad," I said carefully. "Why is the house listed for sale?" Silence. Not confusion, not surprise. Silence. Then, "Who told you?" "It's public." Another pause. "I was gonna tell you." "When?" "After the offer finalized." My chest tightened. "After?" "I didn't want to stress you." "Stress me." I closed my eyes. "I've been covering the mortgage, Dad, and I appreciate that." "Then why would you sell it without talking to me?" His tone shifted slightly. Defensive now. "It's my house, Claire." There it was. Legal. Clean. Simple. "It's my house." "Yes," I said slowly, "but I've paid over $200,000 in the last year." "That was help. You said you wanted to help." "I did, to keep the house." "I never promised you the house." The hallway suddenly felt too narrow. "I wasn't asking for ownership," I said. "I was protecting it." "Well, I can't maintain it anymore, and the market's strong. It's the practical decision." "Practical? Where are you planning to live?" "I'll downsize. Maybe a condo." "With what money?" "With the proceeds." "Proceeds." The word echoed. "Dad," I said, trying to steady my voice, "are you planning to reimburse me?" Another silence. "We'll figure something out." That meant no. "I need to get back to my appointment," he said. "We can talk later." And he hung up. I stood there for a long time, not crying, just recalculating. I drove straight from the hospital to Evanston. The for sale sign wasn't up anymore. Just a small under-contract rider attached to the post. The front door had a new smart lock. I still had my old brass key. It didn't fit. I walked around the side of the house and looked through the kitchen window. The yellow cabinets were gone. White shaker panels. Quartz countertops. The island had been removed. My mother's curtains were gone. The place looked staged, neutral, erased. That's when something inside me shifted. Not anger. Clarity. This wasn't about sentiment. It was about control. I called the listing agent from my car. "Hi, I'm calling about 237 Linden." "Yes, it's pending," she said briskly. "I'm the seller's daughter." "Oh," she hesitated. "We've already accepted an offer." "When did you list it?" 3 weeks ago. 3 weeks. I had wired $18,600 for a treatment shortfall 2 weeks ago. He had thanked me. He never mentioned showings. Did my father disclose that significant renovations were funded by a third party? "I'm not sure what you mean." "I mean me." She went quiet. "I really can't discuss seller details." Of course she couldn't. I drove to my father's apartment, a short-term rental near the hospital I was paying for. He wasn't there. The nurse said he'd asked to be driven back to the house earlier that week to check on things. That night, I pulled every bank statement from the past 18 months. Every wire, every check, every Venmo labeled roof repair, property tax, contractor. The total came to $214,870. I exported it into a spreadsheet, column by column, date by date. If he closed at asking price after agent fees and remaining mortgage, he would net approximately $640,000. I had kept him solvent. He was about to walk away liquid. The next morning, I requested a copy of the purchase agreement from the county recorder's office. It hadn't posted yet. But the deed history showed something I didn't expect. 6 months earlier, right after I paid the delinquent tax balance, my father had taken out a home equity line of credit, $150,000. I had never seen that statement. The lender correspondence was sent to a P.O. box I didn't recognize. I drove to the bank branch, listed on the HELOC filing. They wouldn't give me details. Privacy policy. Of course. Legally, it was his property. Legally, he could borrow against it. Legally, he could sell it. Legally, I had no recorded interest. But law and equity are not the same thing. I hired an attorney the following Monday. Her name was Dana Mercer, corporate and real estate litigation, downtown Chicago. I laid everything out. The payments, the renovations, the HELOC, the pending sale. She listened without interrupting. "Was there any written agreement?" she asked. "No." "Any email stating repayment terms?" "No." "Any text message acknowledging this as a loan rather than a gift?" I thought about it. There was one message. From him, last winter. "Once this house is stable again, we'll make you whole. Make you whole." I showed it to her. She read it twice. "That's something," she said. "Not definitive, but something." She leaned back. "Right now, the sale hasn't closed. We can file a lis pendens, a notice of pending legal claim, which would freeze the transaction." "On what grounds?" "Unjust enrichment, constructive trust, potential fraud if we can establish misrepresentation." I swallowed. "This is my father." She held my gaze calmly. "And this is $214,000. I drove home in silence. That night, my father called. "I heard you contacted the agent." "Yes. You embarrassed me." "Embarrassed you?" "You're making this complicated. It already is." "I needed liquidity, Claire." "For what?" A pause. "For security." "Security from what?" "From being dependent on you." The irony hit like a physical force. "I've been paying for everything, and I'm grateful." "Then why didn't you tell me?" "Because you would have tried to stop me." He was right. I would have asked for transparency. "I don't need permission from my daughter." There it was again. Hierarchy, authority, ownership. I felt something settle inside me. Not rage, resolution. "You're right," I said evenly. "You don't need permission." "Good, but I won't continue funding treatment without clarity." Silence. "What does that mean?" he asked carefully. "It means if the house closes, I expect formal accounting and reimbursement discussion. You can't put conditions on helping your father." "I can," I said quietly, "and I am." We hung up without saying goodbye. The next morning, Dana filed the notice. The buyer's attorney called within hours. Then my father's. Things were no longer private. They were procedural. 3 days later, I received a letter from my father's counsel. It stated that all financial contributions I made were voluntary familial support with no contractual expectation of repayment. Voluntary. The word felt surgical. I forwarded it to Dana. She replied, "Now we escalate." The buyer walked. We knew he would. No one wants to purchase a house wrapped in litigation. The listing status changed from pending to back on market to temporarily off market within 10 days. My father called that evening. "You cost me a clean sale. You cost me $214,870. That was help. That was reliance." He exhaled sharply. "You're turning this into something ugly." It already was. The next move came through his attorney. a formal demand letter. If I did not withdraw the lis pendens within 7 days, they would countersue for tortious interference with contract and seek damages for lost sale value. Dana read it and smiled faintly. That's posturing, is it? Yes, but it tells us something. What? He needs the sale. That mattered, because if he needed liquidity urgently, there was a reason. We subpoenaed preliminary financial disclosures as part of filing the civil complaint for unjust enrichment and constructive trust. The response was delayed, then incomplete, then heavily redacted, which is how I knew we were getting close to something real. 2 weeks later, the court granted limited pre-discovery access tied specifically to the house proceeds and related debt instruments. That's when we saw it. The HELOC wasn't the only lien. There was a private promissory note recorded 4 months earlier, $275,000. Lender Whitaker Strategic Holdings LLC. I had never heard of it. We pulled corporate records from the Illinois Secretary of State. Registered agent Aaron Whitaker. My brother. Formed 8 months ago. I stared at the screen. Aaron, who had no capacity to help financially. Aaron, who sent flowers. Aaron, who told me over the phone, I'm glad you're there for Dad. The promissory note listed the house as collateral. If the sale closed, Whitaker Strategic Holdings would be repaid before net proceeds distributed. In other words, the equity wasn't disappearing. It was being redirected. I called Aaron. He didn't answer. I texted, call me, now. He responded 3 hours later. Hey, I'm in meetings. Why is there a $275,000 lien on Dad's house under your LLC? Silence. Then, it's not what you think. Then explain what I think. He sighed. It's asset protection. From who? From you, apparently. The words landed heavier than he intended. What does that mean? It means if something happened, if Dad passed and there were claims, it protects liquidity. I am the one paying his medical bills. Exactly. I closed my eyes. You think I was going to sue him after he died? I think things get complicated. They're complicated because you made them that way. It's just structuring. Structuring. Corporate language to sanitize moral ambiguity. How much of that $275,000 did you actually lend him? Another pause. Not the full amount. How much? 50,000. The rest was paper. Paper designed to absorb equity before it ever reached me. It was pre-positioned. Dana was quiet for a long time after reviewing the documents. This isn't just unjust enrichment anymore, she said. This looks like a fraudulent conveyance strategy. Meaning? Meaning they created artificial debt to shield assets from a foreseeable claim. From me. Yes. We amended the complaint, added Aaron as a defendant, added fraudulent transfer, added civil conspiracy. The temperature changed immediately. My father called that night. You're suing your own brother now? He put a lien on the house. It's paperwork. It's deception. It's planning. For what? My betrayal? He coughed. A deep, rattling cough that still triggered something instinctive in me. You're punishing me for trying to secure my future. I secured your present. You're acting entitled. There it was, that word. Entitled. I'm asking for accounting. You helped because you wanted to. Yes. And now you want control. No, I said quietly. I want honesty. The next move was strategic and brutal. His attorney filed a motion questioning my standing, arguing that all transfers were voluntary gifts motivated by familial affection, not reliance. They attached excerpts from emails I had written during the worst months of treatment. I don't care about the money, Dad. We'll figure it out. I just want you healthy. Context removed. Emotion reframed as waiver. Dana warned me, they're going to build a narrative that you're rewriting history. Am I? No, she said evenly. You're responding to new information. But doubt is invasive. It slips in at 2 a.m. I replayed every wire transfer in my head. Did I explicitly say loan? Did I ever say repayment required? No, because I trusted him. The preliminary hearing was set for late November at the Circuit Court of Cook County. Cold morning, gray sky. I saw my father in the hallway outside courtroom 1202. He looked smaller, thinner, but not fragile. Aaron stood beside him. Neither approached me. Inside, arguments were procedural, standing, equitable interest, reasonable reliance. Dana spoke calmly. Your Honor, Miss Whitaker contributed substantial funds specifically to preserve the value of the property in reliance on representations that she would be made whole. Shortly thereafter, the defendants encumbered the property with insider debt to redirect equity. Opposing counsel stood. These were gifts. Adult children support aging parents every day without expectation of ownership. The judge, a woman in her early 60s, looked over her glasses. Counsel, are you disputing that an LLC controlled by the brother holds a lien disproportionate to actual consideration paid? Opposing counsel hesitated. We dispute the characterization. Not the fact. The characterization. The judge allowed the case to proceed to full discovery. No dismissal. No immediate relief. But forward. Outside the courtroom, Aaron finally spoke. You didn't have to drag me into this. You dragged yourself. It's business. It's family. Exactly. That word again. Exactly. Over the next 3 months, discovery peeled layers. Bank statements showed the $50,000 Aaron transferred to my father's account. 3 days later, $48,000 moved back into Aaron's LLC as consulting repayment. Circular. Manufactured. The HELOC funds? Mostly untouched. Parked in a high-yield account. Liquidity existed. He hadn't needed to sell urgently. He wanted to. Because if he sold before I knew about the internal liens, proceeds would distribute under their structure. I would have had no leverage. The betrayal sharpened. Not because he sold the house, because he engineered the timing. One evening, after another document review session, I drove by Linden Avenue again. The house was dark. For the first time in my life, it didn't feel like mine emotionally either. Just an asset under dispute. That clarity hurt, but it also freed me. I stopped arguing from nostalgia. I argued from numbers. The mediation order came in January. Court mandated. Neutral conference room downtown. My father looked exhausted. Aaron looked impatient. The mediator asked one question. What outcome resolves this? Their attorney spoke first. Withdraw all claims. Allow the sale. In exchange, Mr. Whitaker will voluntarily gift his daughter $75,000. Gift. I almost laughed. Dana squeezed my arm gently. My turn. Full accounting, dissolution of insider liens. Reimbursement of documented contributions, or imposition of constructive trust on sale proceeds. Silence. Aaron leaned forward. You're bleeding this family dry. I looked at him steadily. I'm not the one who created shell debt. Mediation failed. Trial date set for early spring. And somewhere in the quiet between filings and depositions, something inside me settled. I wasn't fighting for the house anymore. I was fighting for narrative. They wanted the story to be, daughter helps father, daughter regrets generosity, daughter sues. The real story was, father accepts support, father restructures assets, father conceals, daughter discovers, facts matter, paper trails matter, intent matters. And this time, everything was documented. The trial lasted 3 days. Not dramatic, not theatrical, just methodical. By then, the house was still unsold. The lis pendens had done its job. No buyer would touch it with active litigation tied to title. I sat at the plaintiff's table and watched my father avoid my eyes. Aaron looked straight ahead, jaw tight. The judge clarified the scope at the outset. This was not a probate case, not an inheritance dispute, not an emotional reckoning. It was a civil action concerning unjust enrichment, fraudulent transfer, and equitable relief tied to specific property. Clean lines, my father testified first. His attorney framed him as an aging widower overwhelmed by medical uncertainty. Did your daughter ever present a written loan agreement? No. Did she ever state in clear terms that her financial assistance required repayment? No. Did you believe her contributions were gifts motivated by love? Yes. Love. That word floated in the room like insulation. On cross-examination, Dana stood slowly. Mr. Whitaker, do you recognize this text message? Yes. She projected it on the screen. Once this house is stable again, we'll make you whole. Did you send that? Yes. What did you mean by make you whole? He shifted. I meant emotionally. A few heads in the gallery lifted. Emotionally? Dana repeated calmly. Yes. Is it your testimony that you intended to reimburse her emotional balance? Opposing counsel objected. Overruled. My father swallowed. I meant I appreciated her help. Did you ever tell her you would not reimburse her? No. Did you inform her before taking out the $150,000 home equity line? No. Did you inform her before recording a $275,000 promissory note in favor of your son's LLC? No. Did your daughter continue paying property taxes and medical bills during that period? Yes. And at any point, did you disclose that you were encumbering the property with insider debt? No. Dana nodded once and returned to her seat. Aaron testified next. He tried to keep his tone clinical. The LLC was formed for asset management purposes. How much capital did you contribute to Whitaker Strategic Holdings? Dana asked. $50,000. And how much was the promissory note recorded for? $275. Why the difference? It anticipated future support. Did you provide future support? No. Did $48,000 return to your LLC 3 days after you transferred funds to your father? That was consulting repayment. For what services? Advisory. Do you have invoices? Silence. No. The courtroom was very quiet then. Dana didn't press harder. She didn't need to. The financial forensic expert testified after lunch. She walked through the transfers, the timing, the circular movement of funds. The structure created the appearance of legitimate third-party debt, she said, while actual consideration exchanged was materially lower. Opposing counsel attempted to frame it as family flexibility. But the paper trail didn't bend. When it was my turn to testify, I expected my hands to shake. They didn't. Why did you begin sending money to your father? Dana asked, to prevent foreclosure and maintain his access to treatment. Did you believe the house would be sold without your knowledge? No. Why not? Because we spoke weekly. Because I was covering expenses. Because I trusted him. Did you consider your contributions gifts? No. Why not? Because they were made in reliance on stability, not charity. Opposing counsel approached for cross-examination. Miss Whitaker, you wrote, "I don't care about the money." Did you not? Yes, so at that time you did not expect repayment. I expected honesty. That's not my question. And that's not the issue before the court, I replied evenly. A flicker crossed his face. No further questions. Closing arguments were brief. Opposing counsel returned to one theme. There was no written contract, no promissory note, no explicit loan terms. Dana approached it differently. Equity intervenes where form is used to mask substance, she said. The defendants created insider encumbrances after substantial reliance-based contributions were made. They failed to disclose material financial actions while continuing to accept support. This is not about inheritance. It is about misrepresentation and unjust retention of benefit. She paused. The absence of a written contract does not eliminate reliance. It makes transparency more critical. The judge recessed. 2 hours. I watched snow begin to fall outside the courtroom windows. When she returned, her ruling was direct. First, the court found that my contributions were made in reasonable reliance on representations that the property would be preserved without undisclosed encumbrance. Second, the insider promissory note was deemed a construct lacking proportional consideration and constituted a fraudulent transfer under state statute. Third, a constructive trust was imposed on the property. The house could be sold, but proceeds would first reimburse documented contributions, adjusted for equitable interest. The Whitaker Strategic Holdings lien was voided. The HELOC would be satisfied from sale as legitimate debt. After that, the remaining equity would belong to my father. The judge looked directly at him. Transparency within families is not optional when substantial financial reliance is involved. She did not raise her voice. She didn't need to. Outside the courthouse, no reporters waited. This wasn't a media case, just paperwork. Aaron left without speaking. My father lingered. You could have handled this differently, he said quietly. I tried. You embarrassed us. I documented us. He looked tired, older than he had at trial's start. Was it worth it, he asked. Yes. Not because of the money, because of the boundary. The house sold 2 months later, lower than original listing price. Litigation does that. After closing costs and legitimate debt payoff, $228,400 was wired to me, almost exact to the dollar of what I had spent with modest interest. I didn't feel victory when the funds hit my account. I felt neutral, balanced. The rest, roughly $370,000, went to my father. He bought a 2-bedroom condo near the lake. Cash, no liens. We speak occasionally now. Polite, measured. Aaron and I do not. The house on Linden Avenue was renovated again by its new owners. They painted the exterior blue. The maple tree is still there. Last fall, I drove by once. Not to reclaim anything, just to confirm it still existed in physical space. It did. But it no longer carried weight. The hardest part wasn't suing my father. It wasn't the filings. It wasn't the courtroom. It was accepting that generosity without clarity becomes vulnerability. I don't regret helping him. I regret assuming alignment. Family does not eliminate the need for documentation. Love does not replace disclosure. And equity, legal and financial, depends on both. When I think back to that afternoon in the hospital billing office, staring at a Zillow listing, I remember the feeling of the floor shifting. What I didn't know then was this. The ground wasn't disappearing. It was solidifying. Under structure. Under evidence. Under fact. The house was never the real asset. Integrity was, and that, line by line, held